Hi, I am attorney Chris Batan Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I will discuss concepts and principles of law in under 10 minutes.
So hello again everyone. This is now part 2 of the accession series, and as what I've mentioned in the earlier video, this video will just talk about Article 448. So what is Article 448? Article 448 tells us about the consequences if a builder builds on a land that does not belong to him. And the builder is in good faith, believing that the land belongs to him. That's why he is building there. And at the same time, the landowner is also in good faith. So let's talk about Article 448. Let's begin. Now, what are the rules when the builder, planter, or sower builds, sows, plants on a land not belonging to him? So in 447, you have a landowner using the materials of another building on his property. But in Article 448, it is when your builder, sower, or planter builds on a property that is not his. What are the rules? 448. The owner of the land on which anything has been built, sown, or planted in good faith shall have the right to appropriate it as his own, the works, sowing or planting, after payment of the indemnity provided for in Articles 546 and 548, or to oblige the one who built or planted to pay the price of the land and the one who sowed the proper rent. However, the builder or planter cannot be obliged to buy the land if its value is considerably more than that of the building or trees. In such case, he shall pay reasonable rent if the owner of the land does not choose to appropriate the building or trees after proper indemnity. The parties shall agree upon the terms of the lease, and in case of disagreement, the court shall fix the terms thereof. Now, for us to be able to understand and remember this, I have prepared a diagram. Okay? So there you have the landowner is in good faith, and your builder, planter, and sower is also in good faith. In short, I'll just call builder. Okay, that's BPS, or the builder. Okay. The landowner, good faith, meaning the landowner does not know that somebody was building on his property. The builder is also in good faith because he builds on a property he honestly believed belonged to him. Okay, now, your landowner, the landowner's right is superior. Both are in good faith, but the landowner's right is superior. Why? Because you go back to the general rule. The accession follows the principal. So the landowner now has the right to either appropriate the building by paying indemnity to the builder, or to oblige the builder to pay the price of the land. Okay? Again, two options. To appropriate the building, meaning buy the building. You pay for the building that was built on your property by the builder. Or you oblige the builder to pay the price of the land, meaning you sell your land. Okay? Now, when you say appropriate the building by paying indemnity, how do you measure the indemnity? The law says, Article 448 says, you look at Article 546 and 548. Meaning, you pay for the necessary expenses, shall be refunded to every possessor, but only to the possessor in good faith may retain the thing until he has reimbursed therefor. And then useful expenses also. And then you also follow the rules on expenses for pure luxury or mere pleasure shall not be refunded to the possessor in good faith. But to fix the value of the indemnity, that is your guide. Okay? In short, you pay for the value of the improvement. Now, another option of the landowner in good faith is to oblige the builder to pay the price of the land. However, there are conditions for that. If the value of the land okay, is considerably greater than the value of the building, then you cannot force your builder to buy the land. Why? Because then, for example, he just made a very cheap structure. The structure that he built on the property is, let's say, that's just worth 100,000, but the value of the property is 5 million. It would be very unfair on the part of the builder to be paying 5 million pesos for the property when what he built was only 100,000. That's why the law says if the land is considerably greater than the building, then this option is no longer available to the landowner. The landowner can no longer force the builder to buy the land. They will, however, now be put under a forced lease. In other words, the builder will now have to pay rent to the landowner. The parties will have to agree on the terms of the lease. Now, what if the landowner and the builder cannot agree on the terms of the lease? Then the court will decide for them. That is Article 448. As I mentioned earlier, the option is given to the landowner because his right is preferred. His right is older, and as I mentioned earlier, by the principle of accession, as he is entitled to the ownership of the accessory thing because, again, the accessory or the accession follows the principal and not the other way around. Now, what constitutes good faith under Article 448? As I mentioned, good faith under Article 448 consists in the honest belief of the builder, sower, or planter that the land he is building, sowing, or planting on is his, or that by some title he has a right to build thereon, and his ignorance of any defect or flaw in his title. So that is good faith. When you build on a property, you honestly believe that the property is yours. You really thought that it belongs to you. Okay? In the case of Rosales versus Castlethorpe, in that case, it also talks about this issue. Can the landowner refuse to choose any of the options and compel the builder to remove the building? Okay? In other words, the landowner will not choose to sell the land because it's not considerably greater than the value of the building. And he also does not want to appropriate the building that was built on the property. He does not want to choose the option. He, however, wants the builder to remove the building. Can he do that? Can he refuse to choose any of the options and compel the builder to remove the building? Rosales versus Castlethorpe, the Supreme Court said, the choice belongs to the owner of the land, a rule that accords with the principle of accession, that the accessory follows the principal. Yes, but the landowner cannot refuse to exercise either option and compel instead the owner of the building to remove it from the land. The Supreme Court said he has to choose from the option. Either he will appropriate the building by paying the value of the building, or to sell the land to the builder if the value of the land is not considerably greater than the value of the building. In Sarmiento versus Agana, the Supreme Court said that the landowner cannot refuse both to pay for the building and to sell the land, and compel the owner of the building to remove it from the land where it is erected. The only time that your landowner is entitled to removal of the building is when he chose to sell the land to your builder and the builder refuses or fails to pay for the same. Again, remember, two options. Either he will appropriate the building and pay for the value, or he will sell the land if the land is not considerably greater in value than that of the building. If the land is not considerably greater than the value of the building, he can force the builder to pay. Now, if the builder does not pay after he has already chosen the option to sell the land, then he can be entitled to the removal of the building. So, as what I've mentioned already, when do you say that your builder is in good faith? Again, there is an honest belief of the builder, sower, or planter that the land he is building, sowing, or planting on is his, or that by some title he has a right to build thereon, and there is this ignorance of any defect or flaw in his title. In Kevada versus CA, the Supreme Court said that this covers only cases in which the builders, sowers, or planters believe themselves to be the owners of the land, or at least to have a claim of title thereto. It does not apply when the interest is that of a mere tenant. Why? Because if you're a tenant, then you know fully well that the land does not belong to you. So, in the case of Makasaet versus Makasaet, here, this is an exception to the general rule because the respondents fully consented to the improvements introduced by petitioners. In fact, because the children occupied the lots upon their invitation, the parents certainly knew and approved of the construction of the improvements introduced thereon. Thus, petitioners may be deemed to have been in good faith when they built the structures on those lots. Now, why is it important to determine whether they're in good faith or in bad faith, whether they can be considered a builder in good faith or in bad faith? We have to determine the rights of the landowner. So in this case, although the children knew that the property did not belong to them, but the Supreme Court gave this as an exception because they built their house on the land of the parents due to the invitation of the parents to build on that land. And the parents knew fully well that they were building on the property. And then you have Mores also about tenants again. You cannot say that a tenant built on the property of his lessor in good faith because, again, from the very start, you being the tenant, you know that the property does not belong to you. Will Article 448 apply to a co-owner of a property? The Supreme Court said no, because when you are a co-owner of the property, then you have a right to build on the property. And so 448 will not apply. What will apply is the rule on co-ownership. All right. Now, your builder has the right to retain the improvement until he is paid by the landowner. If the landowner chooses to appropriate the improvement. Because again, we go back. What are the options given to the landowner? If the landowner is in good faith and then someone builds on his property and that person is also in good faith, again, two options. He can appropriate the improvement or sell his land if his land is not considerably greater than the value of the improvement. So, if the landowner already makes a choice and he chooses to appropriate the improvement, your builder has the right to retain the improvement until he is paid by the landowner. What does that mean? In the case of Nugid versus CA, a builder in good faith cannot be compelled to pay rentals during the period of retention, nor be disturbed in his possession by ordering him to vacate. In addition, as in this case, the owner of the land is prohibited from offsetting or compensating the necessary and useful expenses with the fruits received by the builder possessor in good faith. Otherwise, the security provided by law would be impaired. This is so because the right to the expenses and the right to the fruits both pertain to the possessor, making compensation juridically impossible, and one cannot be used to reduce the other. It would be very unfair on the part of the builder if he is being
asked to pay rentals during the period of retention. So, for example, your landowner chooses to appropriate the improvement. He communicates his choice today. But then, he only pays the builder next year. So, there's 12 months. Your landowner cannot tell your builder, hey builder, pay me rent while you are still using that improvement. Why? Because then the landowner may say, okay, I'm not gonna pay the improvement anymore because you owe me rent. It would be very unfair. It would be a circumvention of the law. So since the builder has the right to retain the improvement until he is paid by the landowner cannot ask for the payment of rentals during the period of retention. Now, what if during the period of retention, the improvements have been destroyed by a fortuitous event? Can the builder still compel the owner to pay for the improvements? In Manotoc Realty, the Supreme Court said, where the improvements have been destroyed by a fortuitous event without the fault of the landowner, the basis of the builder's right to retain the premises is already extinguished, hence, there is no other recourse for him but to vacate the premises and deliver the same to the landowner.
So that's it for this video. That is your Article 448. The accession series will not end here. I will continue on the discussion on accession for Articles 449 to 455 in the next video. So again, I hope you have learned something from this, and I will see you in the next.
So if you find this video helpful, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.